Welcome to another episode on the law rapport. In fact, this is a continuation of episode 53, and I will title this episode 53A, and I continue this mini-series of intention in criminal cases. How do you determine intention in criminal cases? And you will remember, or you should remember, from episode 53, I pointed out that intention is the mens rea, or the state of mind of a person who allegedly commits an offense, or who is convicted of committing an offense. And I point out that the mens rea is divided into three categories: intention, recklessness, and negligence. And episode 53 focused primarily on intention. In today's episode 53A, I will focus on the other two elements, or other two categories of the mens rea, which is negligence in criminal law and recklessness in criminal law. How do you determine recklessness and negligence in criminal law? Before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Negligence refers to conduct that does not conform to what would be expected of a reasonable person. Negligence involves the failure to comply with an objective standard of conduct. Negligence arises when, on a subjective test, an accused person has not actually foreseen the potential adverse consequences to their planned actions, but nevertheless went ahead with that action, exposing some particular individual or unknown victim to the risk of suffering injury or loss. To prove negligence, the prosecutor or the prosecution is not required to show that the accused person failed to foresee the relevant risks. It only has to establish that the conduct failed to comply with an objective standard of behavior set out by law. The leading statement describing criminal negligence at common law for the purposes of establishing a test for manslaughter in England and Wales is that of Lord Hewart, CJ, in the case of the Queen and Bateman. In explaining to juries the test which they should apply to determine whether the negligence in particular amounted or did not amount to a crime, judges have used many descriptive jargons such as culpable, criminal, gross or wicked, clear, complete. But whatever words or descriptive phrases are used in order to establish criminal liability, the facts must be of such that, in the opinion of the jury trying the case, the negligence of the accused went beyond a mere matter of compensation between subjects. So it must go beyond civil liability, and it must show a disregard for the life and safety of others as to amount to a crime against the state, and thus conduct deserving punishment. Negligence plays a minor role in criminal liability. It is used to form the basis of some driving offenses, but this has largely been superseded by recklessness, which we will deal with shortly. Negligence, as previously stated, adheres to an objective standard. This is strictly applied, as can be seen in the case of Macron and Riding of 1938, where it was held that a learner driver must meet the standard of a qualified driver. The main role for negligence in criminal law is with regards to gross negligence manslaughter. This requires the prosecution to establish that the defendant owed a duty of care, was in breach of that duty of care, and it resulted in the death of an individual. However, our legislation in the Turks and Caicos have no such charge as gross negligence manslaughter. The construction of Section 3 of the Offence Against the Person Ordinance in the Turks and Caicos Islands, dealing with the definition of murder, in my respectful view, informs me that a person in the Turks and Caicos Islands could be charged for murder based on negligence. Section 3 states that a person who intentionally causes the death of another person by an unlawful act or omission commits murder. Omission here, in my respectful view, could be a failure to comply with some objective standards set by law. Example, a mother neglecting to feed her baby, a caretaker of the elderly starving them to death. By virtue of Section 7 of the Offences Against the Person Ordinance in the Turks and Caicos Islands, manslaughter requires a person to commit unlawful harm to another person. So it does not require intention. So the person could be charged for manslaughter if some unlawful harm that they caused to another person resulted in that person's death. They do not have to intend to kill that person. If they intended to kill that person, they could be proven it will be murder. The current test for establishing liability for this offense was set out in the case of the Queen and Adomako of 1994 and is commonly regarded as the Adomako test. And it simply is whether the conduct of the defendant was so bad in all the circumstances as to amount in their judgment to a criminal omission. So it's whether the conduct of the defendant was so bad in all the circumstances that in the judgment of the jury, or if it is a judge alone trying the matter, in the judge's judgment, that action amounted to a criminal omission. Now I move on to recklessness. Certain statutory and common law offenses allow the prosecution to prove mens rea on the basis of recklessness. In essence, recklessness means the taking of an unjustified risk by an accused person that leads to unlawful harm or damage, or having regard to the circumstances known to the accused, him or her, at the time, it was unjustified for that person to take the risk. The subjective test for recklessness was reaffirmed by the House of Lords in the case of R&G. But before R&G, there were two tests for recklessness, with the applicable test depending on the substantive offense charged. The two tests were for subjective recklessness. It was established in the case of the Queen and Cunningham. This test required the prosecution to prove that the accused had foreseen the risk. On the other hand, the objective test, which was established in the case of the Queen and Cadwell, required the prosecution to prove that the risk would have been obvious to a reasonable person. The prosecution were not required to prove that the accused themselves foresaw the risk. So it is safe to say that the modern definition of recklessness was developed from the case of the Queen and Cunningham of 1957, in which the definition of malicious for the purposes of the Offences Against the Person Act of 1861 in England and Wales was held to require a subjective rather than an objective test. And this took place in a case where a man had released gas from the mains while attempting to steal money from the pay meter. As a result, the gas leaked into the house next door and partially asphyxiated the man's mother-in-law. The Court of Criminal Appeal reversed the conviction by the trial judge because maliciously was read to mean that the result was a reasonably foreseeable consequence of the defendant's actions. The court stated that in any statutory definition of a crime, malice must be taken as requiring one, an actual intention. And you remember in the previous episode, I did indicate that the malice aforethought in murder simply means intention. So the court is saying that there should be some actual intention to do the particular kind of harm that in fact was done. Or two, recklessness as to whether such harm should occur or not. That is, the accused has foreseen that the particular kind of harm might be done, and yet he went ahead and take the risk. again, this type of recklessness is referred to as the Cunningham recklessness. The Cadwell recklessness, which will be based on the reasonable man's test, was overruled by the House of Lords in the case of R&G. The objective test that Cadwell had introduced was phased out, and a form of subjective recklessness was introduced instead for cases involving criminal damage, for example. The majority of the mens rea of recklessness is now tested using the Cunningham test or the subjective test. Now, in the case of R and G and another in 2003, the House of Lords concluded that the objective test could cause unfairness in circumstances where a defendant did not foresee the unlawful consequences of their actions. In this case, the defendants were children who had subjectively not foreseen that their actions would lead to criminal damage. It was therefore unfair, according to the House of Lords, to find them guilty on the basis of the objective test, which is what an ordinary reasonable bystander would have foreseen. So the test is what the defendant himself would have foreseen and not what an ordinary reasonable bystander would have. So the current test in England and Wales is one of subjective recklessness. Here is where I will leave it for today. I hope I have been of some assistance to you. If you have any questions, please leave it in the comment section below, and I will see you in my next episode.